The high profile to the untold, breaking it down, watch the truth unfold. Scandals rise, secrets leak. We got the stories that'll leave you weak. Welcome to Sweet Escape, where the truth shines bright, no time to waste. Crime and fame, we set the scene. Real life stories, raw and clean. Subscribe. Just when it hits subscribe, don't miss the ride. We keep it real, no place to hide. Trials live, got the world on edge. Justice wins like a razor's edge. From the streets to the stars up high, no case too big, we analyze. Yeah.
Calling People versus Kelly Bryant, case number 250216FY.
Good afternoon, Your Honor. Kanika Ferenczi on behalf of the people.
And good afternoon, Your Honor. Cecilia Carantago here on behalf and with Kelly Bryant. She is present from the Oakland County Jail on Zoom, and we have no objection to Zoom, Your Honor.
Thank you, Ms. Bryant. Would you state your name for the record, please?
Kelly Bryant.
Thank you. This is the time and date set that the court scheduled for defendant's motion to modify the bond and for a reasonable bond. Ms. Carantago, you did submit a supplemental pleading, and just to clarify, it references a letter to the court. There was only one letter that you submitted, correct?
Your Honor, this morning, so I obtained a letter from a community support that was sent in a separate email to the court, not into the court file. And then there was also a letter in regards to the medical condition that my client has that was set separate. So there should be one handwritten. Okay, perfect. Yeah. All right. Yep. Okay.
Ms. Ferenczi,
yep, that was just the one.
Ms. Ferenczi, you received those as well?
Yes, Your Honor. I received all those documents this morning.
All right. At this point, the court is prepared to review the items that I had mentioned on the prior date, which were those things that I will address or attempt to address, the factors to determine which pretrial release option is appropriate and under what terms and conditions. I had indicated on the prior date, I'm looking at the defendant's, if any, prior criminal record, any record of appearance or non-appearance, any history of substance abuse, mental condition, the seriousness of the offense charged, the employment history, any financial history as it relates to ability to post bail, the availability of a responsible member or members of the community who would vouch for and monitor the defendant, any facts showing community ties, family relationships, also the length of residence, and any other factors bearing on the risk of appearance or danger to the public. Ms. Carantago, anything you wanted to add that the court did not already have at arraignment?
Well, at arraignment, I think pretrial services verified Ms. Bryant's information, but quite frankly, I mean, many of the things that were put in the motion and the supplement that was added information. I think the court was somewhat concerned about being able to verify the information. I attempted to do that. In the supplement I submitted to the court, I listed all of those factors that the court just mentioned on the record, and listed, I guess what's favorable to my client and what's not, and also how that information was verified. So if the court would like me to, I can go through, those factors, again, as I had mentioned before, both at arraignment and I think also in the first written motion and then in my supplement. I think for Ms. Bryant, we all know the court can't deny bond, so I think everybody's agreeing with that. And then it comes down to whether, essentially a cash bond is appropriate at all, or if it should be a recognizance bond with some type of conditions. And I know the people, will argue that it should be a cash bond. My position is that the only time that the court could do a cash bond is if the court finds either that she's a flight risk or that she poses a danger to the community at large. If the court would like me to, I can go through all the factors that I mentioned and
Let me
information.
interrupt you, Ms. Kirandago, because one of the main things that was of concern at arraignment was the lack of a stable address for Ms. Bryant. That was one of the things that was the focus of the arraigning judge.
That's correct, Your Honor. And Ms. Bryant has a stable residence. She had a stable residence before that, her arrest as well. Now, of course, there's additional concerns because of the publicity that this particular case has received. So Ms. Bryant would not, and I did provide also, I think prior to the last court hearing, the court with the address, and I indicated also who resides at that address for the court. I'm very concerned about putting any of that on the record, given, the kind of posture of this case, but that is with a family member who has also lifelong ties to the community. So Ms. Bryant does have a stable residence to go to. I have also spoken, to other family members, and I spoke to the person who provided a letter to the court, who is also a pillar of the community. Every one of them are willing to, to supervise and I shouldn't say, vouch, but make sure that Ms. Bryant gets to court. And I think, a tether could also assure all of that. The court would be aware 24/7 where Ms. Bryant is. So she was not transient. I know the previous judge made some statements that Ms. Bryant was transient. She was absolutely not transient. She was staying at a residence and had stayed there for quite some time. That is not a residence given the circumstances as they are right now that she would be returning to, and that is mainly due to the amount of publicity that this case has received. So of course now there's new concerns, but she absolutely does have a residence to return to, and I don't believe she was ever transient, Your Honor.
All right.
And I don't think there was any evidence of that either, quite frankly.
All right. As to residence, Ms. Ferenczi, is there any comment?
Yes, Your Honor, I would like to address residency, and then because I only received the supplemental motion this morning, I would like to respond to much of what was documented in that motion, Your Honor.
Okay.
But in regards to residence, what the people find troubling is that the individual that the defendant is being asked to be released to and reside with isn't the one that wrote the letter. That individual is not vouching for her, and I don't believe that individual has appeared in court and is willing to provide that voucher to the court. That is a concern, and it actually speaks to the high level of instability for Ms. Bryant. A lot of the statements about her transient nature is in conflict with what she told police when she was interviewed. So I do find it troubling when the information is, at times it feels like it's self-serving for Ms. Bryant. I'm happy to address the other issues though, Your Honor, in the supplemental motion.
Your Honor, may I address that particular point that Ms. Ferenczi is making? So I will just tell the court, as an officer of the court, I've spoken to many of Ms. Bryant's family members, and here's the reality of things. The children, I think everybody has now known where the children are. And so the children are with family. And so it becomes a very difficult balance as far as, supporting, sending letters. I had conversations with the individual whose address, was offered as a residence, and that individual wanted to talk to Ms. Bryant too. There are issues with setting up, phone accounts for the Oakland County Jail and actually establishing that communication, to be frank with the court. I spoke to that individual about a letter when she spoke to me, and again, this is, as an officer of the court, when she spoke to me, she was absolutely willing to provide that letter, but there was also just a very short amount of time in which to accomplish that, and she had requested to speak with Ms. Bryant first on the phone. And it's my understanding that there was no previous account set up for that, and there was 2 days to do it. So that's the reality of it. So it has nothing to do with the person not being willing to vouch for her. That person indicated to me that she absolutely would supervise Ms. Bryant and make sure, that she comes to court. But again, And I think that's the concern for the court, is that the court would like someone to say they're going to make sure she comes. And that brings me to some other things I put in my motion, which I don't think the people are disputing, that this young lady,
let me stop you for a moment, because on the issue of where she will be staying, the court needs to be convinced that this is a stable residence if there are any modifications to the bond where there's a potential that she could be released. I understand the nature of people being hesitant to come forward given the amount of publicity, but the court has to be convinced that Ms. Bryant would return to court and also that she will not be a danger. So go ahead, Ms. Kirandago.
Yes, so in regards to the return to court, Your Honor, which goes to the flight risk portion of, the bond factors that the court can consider, Ms. Bryant has no criminal history. So there's no history of her, appearing or not appearing in court at all, which means she has no history of failing to appear. She, and this information was verified by pretrial services. In addition to that, Ms. Bryant, and this is in the police report, so I don't think this is something that will be disputed by the people. Ms. Bryant, when she was contacted, so she was contacted by the Sheriff's Department and the officer in charge of this case in regards to this case once the children had been located, and she paid for a Lyft ride to the Oakland County Sheriff's Office to turn herself in to talk to the officers. I've been in practice for a number of years now, and I don't think I've ever had a client who actually paid for a share ride to go turn themselves into the Oakland County Jail, and she did that.
So it might be simpler if I go through the issues that I don't believe are in dispute. One, the fact that Ms. Bryant turned herself in after being contacted. I don't believe that that is in dispute.
It's not, Your Honor.
That's correct, Your Honor. The only issue that I would argue that is in dispute, her ability to cooperate with law enforcement.
Understood. Let me finish going through the items that I'm looking at. There is not a prior criminal record.
We do not dispute that.
All right. There is no record of prior non-appearance or flight to avoid prosecution.
That's understood, yes.
Okay. So the issues that the court needs to hear about are, and the court is already aware of the seriousness of the offense charged, and that is certainly something the court will be taking into consideration in modifying any bond. But we have not heard regarding the employment status, financial history as it relates to an ability to post, ties to the community, ties to family members, and the residency is still an issue. So, Ms. Kirandago, if you can address those matters.
Yes, Your Honor. So in regards to the personal circumstances, which I think addresses many of those issues, Ms. Bryant does have a mental health diagnosis. This is reflected in the police report, and I'll tell the court I did submit a subpoena for her records for CNS, which I noted in my supplement that that's where she was going. I gave the court the name of her case manager for treatment too. It's not enough time to get those records, but this was noted. I also believe it might have been noted in the pretrial services report.
It is
right now. I believe so, and that information was verified, I believe, by her father. So she wasn't receiving any medications, but she was receiving treatment. In regards to her physical health, which is one of the other considerations, I did provide the court with a letter that indicates a medical diagnosis for which she's supposed to be receiving infusions. The jail can't accommodate that. Ms. Bryant also was scheduled to have surgery, which that time has passed, but she has issues with which could be internal bleeding that was supposed to be addressed via surgery, and she hasn't been able to have that surgery. I again submitted a subpoena for those records. It's just simply not enough time for St. Joe's, but I did provide as much information as I could to the court on that. Ms. Bryant also, she is a lifelong resident of the city of Pontiac, which that was verified, I believe, by pretrial services. I also believe that the letter, the community support letter that I provided to the court indicates that that person is a resident of the city of Pontiac and has known Ms. Bryant since she was 14 years old. Also, her information in regards to being a Pontiac resident was verified by her father through pretrial services. I don't think there's a dispute that Ms. Bryant has lived in the city of Pontiac her whole life. She went to school in the city of Pontiac, and she's never left the city of Pontiac. So that indicates that she has strong ties to the community. I also believe that both the community support letter and also pretrial services, as well as information in the police report, indicate that she has family in the area. Her parents are here. I also indicated to the court that she has siblings in the city of Pontiac. She again has community support, which is not family, but family, longtime family friend, who appears to be an upstanding member of the local community, who provided a letter to the court indicating that she was in support of Ms. Bryant. So she absolutely has community support. Again, it's a very difficult situation. So when I say community support, I want everybody to understand that that shouldn't mean that, we should be worried about the children, because everybody has made the children a priority. So I just, want the court to know that. But Ms. Bryant absolutely does have a lot of support in the community. In regards to substance abuse, there's no history of substance abuse for Ms. Bryant that I'm aware. It was not noted in any of the reports, and she has not indicated to me that she had a history of substance abuse or substance use. Even marijuana or alcohol. So I don't think that that is something that should be of concern to the court. But again, if it was, the court could order her into testing to ensure that she's not, using any illegal substances. That's a pretty standard condition of bond. Ms. Bryant also submitted, in regards to income, pretrial services report did note her past history of employment. I noted in my supplement that she was also, prior to her incarceration, she was employed. She was paid through the state of Michigan. I could not obtain that information because it's confidential information, and it was something that was shared with me a few days ago. So I was not able to obtain verification, but Ms. Bryant did inform me of who the person at the state of Michigan that was responsible for her was, and she provided me with that name. Unfortunately, it's a very common name within the Department of Health and Human Services, so I was not able to obtain specific information. She does have a pay stub. It's at the residence she was at. I made contact with the person who resides there. They were trying to locate the paperwork for me, but they were not able to locate it as of yesterday evening at 9 p.m. But she was employed, taking home about $800 a month. So that was what she was making at the time she became incarcerated. That amount of money a month would still make her indigent, which she's already been found to be, which goes to her ability to post a monetary bond. Oakland County appointed her an attorney because she didn't have the funds to hire one. So I think, but she did have employment, which is also something that ties with the community. I just think her employment would not be enough, to post a monetary bail. I don't believe there's any family members that have funds. Like I said, they're all caring for the children, and that's financially stressful too. Nobody has money to post bond for her. At this time, I don't believe. The employment history, what was disclosed to pretrial services, was verified. Again, it appears that her father verified that information for pretrial services. Some of the other employment that she had was also, verified through the family court case. There was discussions about that. I'm not entirely sure if Ms. Ferenczi was on there when that took place, but it is also information that's been provided to the Department of Health and Human Services. The risk to the community, that's one of the factors the court must take into consideration as well. And again, the chance of her reappearing, I wanted to just address that briefly. The court could address that by placing her in a steel cuff tether that she can't remove from her leg. The court would be aware at all times where she is. If she failed to appear, the tether would indicate where she is. But again, Ms. Ms. Bryant turned herself in and actually was inquiring, and I think that people would agree as to the charges she was facing. She knew she was potentially facing serious charges. She's aware. I've met with her probably 10 times at this point. She knows what she's facing. I don't have any reason to believe she has nowhere else to go. So she's a Pontiac resident. She's been here her whole life, and I think if she wanted to flee the state or go somewhere, she'd have done that, already, I think, because she was, again, not apprehended.
So I'm going to allow the prosecutor to respond to what you have said so
Yes,
far, but
sorry.
I will change a couple of things or modify. You indicated that pretrial services had verified her employment. That's not what the report reflects. It reflects that the defendant reported she had been unemployed since August of 2024. No sources of, no sources of income were reported. Prior to that, she indicated where she had been working for about a month. So I realize that you are saying you have not had an opportunity to get all of that confirmation, but that you have been seeking it. Ms. Ferenczi?
Thank you, Your Honor. Your Honor, as the court has already noted, the allegations and charges in this case are very serious. Defendant, as the court is well aware, is being charged with 3 counts of child abuse, first degree, and there is a very high likelihood of conviction. The people are happy to provide any facts or evidence if the court would like to hear it, and the initial guidelines call for significant jail time. Your Honor, as I already indicated, the people do not dispute that Ms. Bryant turned herself in and that she cooperated with law enforcement. But as the court is also aware, that does not equate any sort of assurances that she will appear in court. In regards to the mental health diagnoses and that she was being treated by CNS, there's no proof of a diagnosis, nor were any dates provided to confirm that this is accurate. The people at this point do not believe the defendant is a reliable source of information. She has a history of concealing and deceiving. That is what we have here, Your Honor. And without any sort of proof, I do not believe that the court can use that as accurate information. In regards to defendant's physical health, again, there was no verification of this medical condition. What was provided was a treatment plan from the clinic at Oakland County Jail. And it seems like she is receiving that treatment that is necessary at the clinic. The clinic deems is necessary. There was an additional allegation that the defendant needed transfusions and a possible procedure, again, not supported by documentation. But Your Honor, regardless of that situation, I would be hard-pressed not to address the reason why we're here today. The reason we're here today is because defendant did not provide her own children, the victims here, with basic medical care, basic needs for years. And this irony of her condition right now is not lost on me. And it seems like she can and is being treated appropriately at the clinic at the county jail. Your Honor, in regards to Ms. Bryant's employment history, again, no proof was provided about her employment status. And as the court has already highlighted, the information that was provided has not been confirmed even with pretrial services. So again, the people do have a concern that defendant is not a reliable source of information. What the people can confirm is that Ms. Bryant abandoned her children, or the victims in this case, in an unlivable residence where several rent payments lapsed. In regards to defendant's ties to the community and the support alleged in the supplemental motion, upon information and belief, the statements that Ms. Bryant had made to the police are quite the opposite regarding her level of support. Again, she has a history of deceiving those who were attempting to support her for years. And it is difficult for me to imagine that all of her beliefs about her alleged support systems have completely changed within 2 weeks of her being in custody. And honestly, it does feel self-serving, Your Honor. The letter that was provided to strengthen her community support argument was not, again, as the court has already heard, was not from the individual who she is requesting to be released to and reside with. That individual in the letter wants to remain anonymous. How is that considered a voucher or a support for the defendant? In the letter, the individual does not make any statements about how they intend to assist the defendant if she were released, and when the last time they even spoke. That individual also admits that the defendant lied about the victim's whereabouts. They also stated the defendant knew that this individual was there if she needed help, but defendant never reached out. This is all very troubling to the people, and it is telling about the serious instability of defendant's support and her willingness to rely on that support. No one is willing to vouch for the defendant. Your Honor, in regards to defendant's potential flight risk, the people do believe the defendant is a potential flight risk with the level of local and national attention and her lack of community ties and stable housing. Most importantly, we believe that she does pose a danger to the community, specifically the victims who are members of the community, who she egregiously and intentionally neglected for years. And one other point the people want to address is the risk of reoffending. The people do believe the risk of reoffending is high here. Again, in her own statements to the police, while she was cooperating with law enforcement, defendant was not accepting or acknowledging what she did, which places a high risk of reoffending. And Your Honor, our request has always remained the same. We are requesting a high cash bail, no cash surety, no 10% provision, Your Honor.
All right, thank you. Ms. Kirindongo, this is your burden to modify the bond at this point, so any comments that are not repeating what you have already said, but anything else in conclusion to your argument?
I will try not to repeat myself, Your Honor. I just wanted to say that in regards to the bond amount or the kind of bond, quite frankly, the court would be much more assured of Ms. Bryant's appearance if the court was to do a surety bond, because it would involve potentially a bail bondsman who would also, in addition to any other supervision the court would order, would also be supervising her whereabouts. So actually asking for a cash only bond, I think on behalf of the people, for me, would be less of assurance of her, if that's what they're going to argue, of her appearing. A cash surety bond, a surety bond on the other hand would involve another party being a bail bondsman. That all being said, Your Honor, I think I provided a lot of specificities in the information that I provided to the court. Reality of it is that, you can't get this information in writing in 2 days. Nobody ever has that information when a person is being arraigned at, first arraignment date. And, again, given the level of attention this case has received, it's been difficult. The person signed their name to a letter, so the court knows who this person is. And I think everybody can appreciate, given the level of attention this case has received, why people don't want to show up on screen here with all the cameras and the news. And, I don't think that that's anything that would be abnormal. That being said, I think if the court was to follow the bond statute, again, Ms. Bryant's bond, I don't believe should be a cash bond. It should be a recognizance bond with conditions, which as I indicated, could include a steel cuff tether, pretrial supervision, mental health treatment, drug screens. And, all of those things would assure her reappearance and would also assure that the court knows where she is. So I'm asking based on that. And I think, in regards to reoffending, we know who the complaining witnesses were. I don't believe there's any risk of reoffending. The children, again, would not be in Ms. Bryant's care.
All right, thank you. At this point, the court did set this for a separate hearing in order to review whether there should be a modification of the bond. And as I indicated, the party seeking the modification had the burden of going forward with this. So the real question for the court is there a substantial reason to modify the original bond as set? Now, the purpose of the bond and pretrial release conditions are to ensure the defendant's return to court and also the protection of the public and alleged victims in the case. The purpose of the bond is certainly not to punish. Even though this is an extremely high impact case, there is much interest in the outcome of this case and in the bond. But the law is very clear that with certain exceptions, a criminal defendant is entitled as a matter of constitutional right to have a reasonable bond or bail established for pretrial release. Cash bond is permissible if the defendant's appearance or the protection of the public cannot otherwise be assured. The court recognizes that this bond review hearing was set in a fairly short period of time, and some of the information that I requested, according to defense counsel, could not be provided within this time. I'll also note that the principal charges in this case are felonies, but not strictly assaulted crimes under the court rule. So, at this point, I have reviewed all of the factors that the court is to take into consideration in determining the proper bail. The court has also reviewed the pretrial services report, and in that report, there was still a question as to the residence. However, for purposes of going forward, we will use the address that is listed on the complaint and also in the pretrial services report. In terms of the mental health concerns, the court will address that as a condition of bond. I am still not satisfied that the court can at this point say that there is a guarantee of a return to court. The defendant has not been a flight risk in the past. However, the potential penalty in this case is quite high given the nature of the charge. The protection of the public and the victims is also a concern, and I do share some of the concerns that were mentioned by the arraigning judge in terms of the defendant's potential to reach out to the alleged victims, the children in the case, to try to influence any testimony, and I'm going to deal with that issue. So, I realize that there may be a need to do further review of the bond, but I do find that the court has an obligation to set a reasonable bond, and the current bond amounts to a denial of bond. So what I'm going to do is modify based on the information that we have that is verified. So I'm going to modify the bond in this case. I'm still requiring a cash bond for purposes of ensuring that the defendant returns to court, to give further support to protection of the public and to prevent reoffending. But I'm going to reduce the bond to a $50,000 cash bond at this point with the following conditions. The defendant will be on pretrial services supervision. There's to be no alcohol or illegal drug use, no possession of a weapon, no assaultive conduct of any sort while this case is pending, no contact with any child under the age of 18, absolutely no contact with the alleged victims in this case. That means no contact at all, including no personal contact, phone calls, text messages, no reaching out to parties who have control of those children right now, no contact with them whatsoever. I am going to impose a home confinement electronic monitoring device. The defendant may not leave home except for medical emergencies, court appearances, court-ordered testing. And if employment can be verified, it is not verified at this point, then seeking and maintaining employment. But at this point, that has not been verified. So I don't want there to be any confusion in indicating that the defendant can go to and from work. We need verification first. Any other travel will require permission of the court. No return to the address of the alleged incident. No return to the address of the alleged victim. Any changes of address would have to be provided to the court within 24 hours. Those would be the modifications to the bond at this point. Any questions as to what the court is requiring? And I will note that Ms. Bryant, be aware that if you violate any condition of release, you would be subject to arrest without a warrant and may have your bond forfeited, revoked, new conditions imposed in addition to any other penalties if you are found in contempt of court. Any questions, Ms. Kirandongo, as to what the court is requiring?
Just a clarification, so that's still no surety?
Correct. Ms. Ferenczi, any questions?
No, Your Honor, thank you.
And if, Ms. Kirandongo, as further information is received, I know you have subpoenaed some information, you can provide that to the court. The court is willing to do an individualized review later as well. And also, if I did not indicate, a mental health evaluation and following any treatment plans as a condition of bond, since mental health conditions were reported.
So she would be able to leave in order to get that accomplished, I'm guessing, correct, even though it's not a medical emergency. It would need to be a separate, I think, exception to the home confinement.
That would have to be something that pretrial services will be further involved in.
Thank you, Your Honor.
All right. Thank you. Ms. Ferenczi, any questions?
No, Your Honor, thank you.
All right. The next court date is scheduled for April 15th at 2 p.m. That will be on Zoom. If there is a need for some other review, I'm confident that the parties will raise that by motion.
Yes, Your Honor.
All right. Thank you.
Thank you.